friends, today I'll be discussing about privity of contract. First, as usual, I'll go forward with the introduction and then I'll move forward with privity of contract. Then I'll discuss the exceptions. Then I'll be concluding my lecture. Let's get to the basics. What is the contract? The contract is nothing but an agreement enforceable by law. For a valid contract, there must be a proper offer, acceptance, consideration which is lawful, object which is lawful, competency of parties, and free consent. Let me illustrate regarding privity of contract. Let us suppose that there is a girl named Ananya. Mr. Iyer wants to get her married and he searches suitable bridegrooms for her. On the day of marriage, they realized that the food they had ordered was not what was delivered. Ananya, who was nervous and anxious, lashed out at the caterer and told that she would take the matter to the court. You tell me after the lecture ends whether she can sue in the court of law or not. A third party to a contract cannot enforce the terms of contract, but there are exceptions to it. So let us get in depth and learn about privity of contract. Beneficiary cannot enforce the terms of contract even though he is taking the benefit out of the contract. In Tweedle versus Atkinson, the son-in-law sued the father-in-law because the father-in-law had promised to pay him some amount if he married his daughter. But the contract was not between the son-in-law and the father-in-law, but the son's father and his father-in-law. The son-in-law was the beneficiary to the agreement and he was not the party to the agreement, and hence he could not enforce the terms of contract. The position under the English law is simple, that the consideration must move from the promisor to the promisee, and a stranger to a contract cannot enforce the terms of contract. But let's get practical. A beneficiary to a contract should be able to sue the other parties to the contract. In Bestwick versus Burswick, the widow of the defendant sued the plaintiff. The plaintiff gave opportunity to work for defendant in his firm, and later on, after the death of the defendant, they assured that they would pay the widow an annuity of £5. Later on, they did not pay her £5 every month. The widow brought an action to recover the amount and the arrears. It was held that in her personal capacity, she could sue the contract, thinking about the practical application, but the English jurists were not convinced with it and stated that she could not sue in her personal capacity, but as an administrator, she could sue and recover the amount from her husband's estate. In Jamnadars versus Pandit Ram, the same principle in Tweedle versus Atkinson followed. A borrowed 40,000 by executing a mortgage of a zamindari in favor of B. Subsequently, the property was sold to C for 44,000 and allowed C, the purchaser, to retain 40,000 on the price in order to redeem the mortgage if he thought fit. B sued C for the recovery of mortgage amount, but he could not succeed because he was not party to the agreement between A and B. In Khwaja Muhammad Khan versus Nawab Hussaini Begum, it was held that under the Muslim law, marriage was considered to be a civil contract. So, the consent was given by the girl's father. So, the question arose whether the girl who was the beneficiary of the contract could enforce the contract or not. Later on, the judges realized that this falls under the exception of the privity of contract principle. Let us deal with exceptions to the rule privity of contract. Let us deal with the exceptions to the rule of privity of contract. The first one is beneficiaries under trust or charge or other arrangements. In Gregory and Parker versus Williams, Parker was indebted to both Williams and Gregory. Parker assigned all his property to Williams in satisfaction of a debt, and Williams promised to pay Parker's debt to Gregory. Williams failed to pay, but he was held liable to Gregory in terms of his promise with Parker. Let me give you an illustration. Either you, as a passenger in an aircraft, can sue the airlines company in case you succumb injury during the journey. The second exception to the rule of privity of contract is marriage settlement, partition, or other family arrangements. Let us suppose that there were two brothers who, on partition, agreed to give equal amounts to their mother as maintenance. The question is whether the mother could enforce the terms of contract. The question is answered. Yes, the widow can enforce the terms and conditions of the contract. The third exception to the rule of privity of contract is acknowledgement or estoppel. In N. Devaraja Aras versus Ramakrishnaiah, A sold his property to B under a registered sale deed and left a part of the sale price in his hands, desiring him to pay this amount to C, his creditor. Subsequently, B made part payments to C, informing him that they were out of the sale price left with him and that the balance would be remitted immediately. B, however, failed to remit the balance and C sued for the same. The suit was held to be maintainable, though originally there was no privity of contract between B and C. B having subsequently acknowledged his liability, C was entitled to sue him for recovery of the amount. Due to paucity of time, let me conclude by stating that privity of contract meant that contractual parties are the only ones who could enforce the terms of contract. There are exceptions to it. The first one is beneficiaries to a trust. Second one is marriage or family agreements. Third one is acknowledgement or estoppel. Sorry, I forgot to discuss the fourth exception, that is covenants earning on land. In Turk versus Mokhe, it was held that a person who purchased the land with a notice that the owner of the land is bound by certain duties created by an agreement was bound by it, although he was not a party to the agreement. Do let me know in the comments the questions asked in this lecture. Thank you for listening to my lecture.